Hello, everyone. My name is Gary London, and I am Senior Principal of London Moeder Advisors. And this is part of our continuing series on all things related to real estate and land use. And I have a really interesting setup for a conversation today. You're looking at Anna McPherson and Marcela Escobar from Atlantis Group, and I've asked them to join me so that we can have a discussion on the new bill that the governor of California, Governor Newsom, just signed into law that basically allows for a new CEQA exemption for infill residential and mixed use projects. And I thought I couldn't think of anybody more appropriate or expert to have this discussion with than Marcella and Anna, who spent all of their time uh, working with developer clients uh, within the San Diego region, maybe elsewhere. You'll have to tell me if it's elsewhere, uh, to get projects approved. And they're absolutely experts at this. And I've worked with them on a number of projects. Anna is the principal environmental consultant with Atlantis, and Marcella is the founder, president, CEO of Atlantis Group. And both of them, both of you ladies come out of the city of San Diego. So maybe just briefly, you can each discuss your backgrounds, and then we'll dig into exactly what this bill does and doesn't do, and how it's going to impact the development entitlement business going forward.
Thank you, Gary. So I'll go ahead and start. Marcela Escobar, as was mentioned, President CEO of Atlantis Group. I've been doing development for more years than I care to admit, and hopefully they don't show, but formerly was the Development Services Director for the City of San Diego, as well as the Planning Director for the City of Carlsbad, and have spent my entire career in development. For the last 17 years, we've had Atlantis Group, where we help our clients essentially obtain entitlements through jurisdictions throughout San Diego County, and some outside of San Diego County as well. I really want to turn this over to Anna. Anna really is our environmental professional who's been tracking CEQA and practicing CEQA and implementing CEQA for more years than we probably care to admit also. So Anna, I'll turn it over to you.
Sure. Yeah. Again, Anna McPherson, Principal Environmental Consultant. I'm a veteran too, of working with the City of San Diego. I kind of did everything over there in the realm of planning, in the world of planning. Did historic preservation, practiced CEQA and managed CEQA and historic preservation. Also did land development code, municipal code. I was on that team. I was a part of the team that wrote the 2008 general plan. So I worked with long range and community planning, worked with communities up and down, coastal communities, inland communities. So I have a background, a thorough background and a complete background in land use planning and entitlement. I was also a permit planner and process development project. So learned what it looked like when the rubber hit the road. If we can go ahead and just kind of jump in.
Yeah.
I was glad that Gary reached out to us because we did witness basically what I would consider to be some of the most comprehensive reform to the California Environmental Quality Act, what we affectionately call CEQA, in the last couple of decades. This was the several legislators and the governor were tired of everyone nibbling around the edges and trying to make it incrementally better. And so they moved forward with some fairly significant reform. The way that it got, two bills were working their way through the legislature. The way that this got adopted, though, is that, and I find this to be very interesting because it shows the commitment of the state. Governor Newsom refused to sign the budget bill unless CEQA reform was included. And so the two bills that had received approval, overwhelming approval in the legislature, the two bills that were addressing those issues were dumped into budget trailer bills. And so when the governor signed the budget, he signed those bills into law, and they became effective immediately on June 30th, 2025. Most people were unaware of that. Jurisdictions were unaware of that law was on the books as of the moment that the governor finished signing it, before the ink was dry. So we started getting the alerts and started looking at what had passed, and we're pretty impressed that what we had been seeing working its way through the legislature actually made it into law. There's two pieces. One is called AB 130. That's I believe it's referred to as a housing bill, but it includes the CEQA reform. And then SB 131, that is also CEQA reform. I'll start with just giving you broad brush on the AB 130. I've seen it referred to as AB 130 exemption. It is a new statutory exemption for housing projects or housing, quote unquote, rich projects, meaning you can have a mixed use project, but you have to have a dominant housing component. The projects do not have to be affordable. Of course, they can be affordable. It is a fairly what we like to refer to as a clean exemption. The big thing to remember, I think, that the stuff that we're super excited about is it resembles the 15332, the class 32 exemption that was called infill, but it is not subject to the exceptions that could kick you out of that category. And it has expanded the acreage requirement from 5 acres to 20. So any project that meets the other criteria, which is pretty easy to meet, is from 20 acres and less, now qualifies for that exemption. So you can see big difference between 5 acres and 20 acres.
So I think part of what we're going to see there, Gary, is hopefully more housing production, because this will, for some of the infill sites in particular, where somebody is able to maybe assemble multiple parcels and do a slightly bigger project, where they maybe would be hesitant in the past to assemble multiple parcels because that would move them from ministerial to discretionary. Now with this new CEQA exemption, they might actually consider that. So we're hoping it opens up opportunities.
Right. And
Right.
I should say at this point that I intend to do another video that sort of does a deep dive into what we think the housing development and economic consequences of it are. So we'll certainly raise this when I do that video. But it also invites me to mention the fact that we're talking about discretionary projects, right, Anna?
Right. Ministerial projects are already exempt from CEQA. So these are the projects that are not fortunate enough to be ministerial. These are the projects, but for some reason or another, they're having to do some kind of, tentative map, or they have habitat on the property or whatever that they've been kicked into discretionary. So this opens up a whole new statutory exemption. So project makes application just by meeting the criteria that's listed in the exemption. In all likelihood, they'll be able to qualify for it.
Can I add one thing? So, because as Anna mentioned, AB 130 was not just a CEQA bill. It actually included other housing provisions. So interestingly enough, one of the things that AB 130 did for ministerial projects is that it now expands the Permit Streamlining Act to apply to ministerial projects. And that is significant, maybe not in jurisdictions like the city of San Diego, which is very judicious about meeting their deadlines to get projects through. But in some of the smaller jurisdictions where they drag their feet out on building permits, this is going to be very significant just for the building permit side of it. So that's important. I think the other thing is other 3 points that are important to note is that AB 130 also codified capping the number of public hearings for qualifying housing projects to 5. That had been in previous legislation that was kind of debated, and so now that's codified. It also makes permanent the provisions of the Housing Accountability Act and the Housing Crisis Act, including the builder's remedy that is now codified. And it removes certain California Coastal Commission appeal rights for specific residential proposals. And that is huge. So
why is that?
Because as we know, if you have a project that's, within Coastal Commission jurisdiction, it is highly likely that your, NIMBY opponents could use the Coastal Commission to basically continue to hammer your project out. So
and usually once you've gotten you have to get your permit from the city first, the jurisdiction first, then you go to coastal to get the coastal permit. that can add another year or two to
So,
project processing.
and it's interesting because this all has come out on the heels of the Palisades fires. And immediately the governor essentially pushed a moratorium in on both coastal and CEQA for that. So the question that we in the development community were asking is if you can exempt because of wildfire, what's the whole purpose of the thing anyway? And so this bill from a 30,000-foot perspective is sort of the response to that, which is there really wasn't a purpose. We really should be able to go through these kinds of infill projects without these added burdens. Is that how you see it?
Oh yeah, absolutely. I think if you look at, I watched the signing ceremony, and one of the points that Assemblymember Wick made was these are projects that are being located in the places that we want them to be.
Right.
I mean, because there is a requirement that it be in an infill area, be in an infill site, and it provides a definition, a loose definition. But in terms of us who are working with jurisdictions, these projects are infill projects. So it's they're in the right places. And we know that we don't have like open greenfields. We don't have the resources. These in most instances, these are redeveloping either vacant sites that are surrounded by development or sites that have already been developed, and they're going to demo and they're going to build anew, and they're going to build more intensely and more transit friendly. So this is rewarding those projects instead of punishing those projects. This is rewarding those projects for locating in the right places and building to the density that we want them to build to.
And that's significant, Gary, because I mean, to the governor's credit, and I'm not always a fan of but he has done more through forcing the hand of this bill than has been done in decades in CEQA.
Yeah, yeah. So it's I don't want to spend, we put out Atlantis Group put out an explainer of the bill, so I don't want to be too boring and just tell you, what their qualifications are. But I mentioned the 20 acres because that's significant. The project has to be consistent with the plan and the zone, which again, most of our projects are. And it also kind of speaks to, if the plan and the zone don't quite match, if a project meets one of them, that's good enough. That's specifically spelled out in the law. That's a big deal because I've been on the processing end of that when I worked for a jurisdiction where we were juggling whether or not we could actually do that. And actually, City of San Diego was challenged on that. The lawsuit went all the way up to the state Supreme Court. City prevailed. That was one of my projects where we had to fight to say that yes, it did meet. It was consistent. Okay, that nonsense is written out with this new legislation. The project has to meet a certain density, and it depends upon it's subject to a certain section of state law, but that ranges from 10 to 30 dwelling units per acre, depending upon where your jurisdiction is. In the city of San Diego, you'd be looking, at like 15 to 20, I think. And that the city of San Diego has tons of sites that allow much more intensity in that, and that's what is being encouraged. But in smaller jurisdictions, if you can meet 10 dwelling units per acre, you can qualify. There are, one of the things that, as I mentioned, that would kick projects out of being able to qualify for an exemption is the first section of the categorical exemption section in CEQA, and those called the exceptions. And these were dreaded because these are the things that groups will challenge on, will sue on. And it was, if you are one of these things, then you can't use this exemption. And some of them were very loosey-goosey, like being a unique site, cumulative impacts. But some of them were really hard and fast, and they didn't make sense. Like if you were on the Cortese list, which is a hazardous materials sort of site database, but anything that would have occurred on the site could have been remediated and dealt with 20 years ago, but you're still on that list, that kicked you out of the exemption. So the way that the law deals with it is it requires a preparation of a phase 1, which is an environmental assessment. And then if for some reason something is found in that phase 1, which is a recognized environmental condition, a REC. You just have to deal with it. That's all.
And I think one thing, Anna, to that point, Gary, you know, there was opposition to this bill, as you know, and there were concessions made in the adoption. So what Anna just described was one of the concessions that was made in the adoption of this bill for the environmental groups that were concerned about hazardous materials on site, was this preparation of phase one. So I don't want anybody to think that this was just slammed through without any concessions made to the groups that had environmental concerns, because they did address as many of them as they felt they practically could. So,
And there were also,
And
go
I
ahead.
would just say very quickly that a lot of projects, they, as part of their, you know, when they're doing their due diligence, a lot of projects will have a phase one. A developer will do a phase one because it's good practice. You need to know what's on your project site. So a lot of our clients, Marcela, come to us with phase ones in hand. So that's pretty common, and it's not an onerous, a document. It's not like a traffic study or something.
There are also construction labor standards that were imposed in this as well.
yeah,
For larger projects.
for larger projects, not for the smaller ones.
And then for actually projects over 50 units in the city and county of San Francisco. So you can
Just San Francisco.
Yes, I mean there are, if it's over 85 feet, then you're subject to certain labor standards, and then city and county of San Francisco. So yeah, they're there. That they had to get labor on board, and they were able to get labor on board.
And quite frankly, I'll kind of step in here for a minute because everyone's so afraid of labor, and I don't know why. I mean, at the end of the day, you take, you know, we are a pro-labor state, and we have to recognize that. And as we should be paying people fair wages. I mean, we see what's happening on the streets right now from people, you know, who are not being paid fair wages, being deported from our country. And I think the reality is, you know, on some of these larger projects that all they're asking for is to use, you know, to pay fair wages, and I think that that's a reasonable compromise that was reached. So
I don't think there's any question of that. On a practical level, do you have a project or can you think of projects that you've been involved with or currently involved with that are going to be directly impacted by this? Maybe tell a story about a project.
Would be able to use it.
Yeah.
it's so new, Gary, that I don't know that I mean, this is literally, as they say, hot off the press.
Yeah.
So I think we're still all just trying to evaluate it and talk to the jurisdictions to see how they're going to implement it.
Right.
Because the jurisdictions have been completely caught flat-footed. They didn't, you know, again, it went into effect right away. So I think until we have a chance to have some dialogues with the different jurisdictions, and the city of San Diego being, quite frankly, the most pro-housing, pro-business friendly, we'll probably take the lead on this, and set the tone for a lot of the jurisdictions. So I think it's really going to take some conversations.
But
I will tell you, Gary, that there was one, as soon as it came through, we started looking at it. That project had already qualified for the class 32, but we explored it, you know, because you look at all your options. One of the requirements for use of this statutory exemption is tribal consultation. And otherwise, categorical exemptions are not subject to tribal consultation. In this particular instance, that would have caused us a couple months delay. So we decided to move forward with the class 32 since we qualify and we have staff support for that. But were we dealing with like getting ready, gearing up to do a document, I would seriously push in the direction of doing that tribal consultation, because if it's in an urban infill area, there's not going to be tribal issues. The other thing too that's interesting is that if for some reason the tribe said, okay, we'd like monitoring or something like that, and without this exemption, you would be into a document. You would be into the preparation of a document. This legislation allows you to include that as a condition and maintain the exemption. So no preparation of an environmental document.
So much as the city of San Diego itself is overlaid with complete communities, could you sort of explain what impact that might have or not have?
So the Complete Communities program, Housing Solutions, definitely. So it's an overlay and it applies throughout the city. One of the great things it did is it kind of moved a lot of types of projects into a ministerial project status. So it took them out of CEQA. But there are some projects that can't get away from being discretionary. If there's a resource on the site, if they're doing some sort of, tentative map, or there's something else that's kicking them into discretionary. So and in that instance, even if you were complete communities, you still had to deal with the environmental. Some projects were preparing a 15162s, meaning they were looking at if there were any prior environmental impact reports on the site and doing consistency analysis. Still takes a lot of time. You still have to do a ton of work, and you have to prepare a checklist, and it looks like a document. In this particular instance, a lot of these projects are going to be able to qualify and meet using the AB 130 exemption now. So it will help those projects out. And then, as you know, there's a lot of land area that's not within complete communities, again, that still want to redevelop, and the city encourages redevelopment everywhere in development. Those will be able to take advantage of this. So it's overall, the other thing I think that is really good too is they addressed the issues, because this was sort of again, one of those areas where everybody was trying to figure out how to handle it, and that's projects within 500 feet of a freeway. So again, written into the legislation, if you're within 500 feet of a freeway, you have to implement an HVAC system, which again, most projects have an HVAC system, and you have to use a certain level of filtration, and you can't have balconies facing the freeway. So that's written in. Your project design does that. You don't have to worry about that issue with this exemption. Your project's exempt.
The bottom line is, it seems very, very innovative. It seems like more reform than we've seen in decades. It's brand new.
Yeah.
Everyone's trying to figure it out right now, and it shall remain to be seen. But it's hard to believe it won't have some positive impact in moving the needle. It's got to, because it's some of the most significant reform that we've seen.
We have high hopes, but Marcela is emphasizing, and I think this is something to emphasize, we got to see it in practice.
Yeah.
We're as consultants, we're going to start pushing it. We're going to do, we would encourage people to come to us. We will look at that project. We will work through, see if we can qualify, and move that forward. Because
one of my questions: how's this going to impact your business?
Well, we hope that it makes it easier for us to get discretionary projects through. I do think it's going to reduce cost. Preparation of a document, even if you're doing something like a checklist, it takes hours and hours of time. I prepare them.
Right.
And it's a review process. You go back and forth. This again is checking the boxes. I've spoken with City of San Diego staff, and I think they're really trying to wrap their heads around this. But one of the things they're talking about is developing a checklist, which would be fantastic, meaning it would be a checkbox thing.
Yeah.
Where it would be like, within 500 feet, implements HVAC system, no balconies. Yeah, without not so much evaluation as confirmation that
it becomes a little bit more objective rather than subjective.
Yes.
I think if you think about it also from the perspective of litigation, and I'm not an attorney, I always joke, I just play one on TV, right? But from the perspective of litigation, having an exemption that has some very clear criteria is a lot easier for a judge to say the city did exactly what they were supposed to do, as opposed to, if you had a mitigated negative declaration with some subjective analysis in there that can then be challenged. It's just, this is where a lot of times with our clients, if we're on the edge and we couldn't find an exemption, we would push them to an EIR because the statute of pardon me?
I was going to say because it's safe.
Because it's safer, because the standard of review is much easier to deal with in courts. So we think this will make projects quicker, more affordable, open up opportunities for people to assemble sites where maybe they weren't considering, anything other than a smaller site. Now they might think of something up to 20 acres, where before they would were only look at up to 5 acres. So we do think at the end of the day that this could have a lot of tremendous benefits, but remains to be seen.
Well, I guess I got a couple more questions. One is big projects, like for instance, in the city of San Diego, the sports arena project. What do you think the practical impact would be of that kind of a project?
Is it over 20 acres?
Yeah, it's over 20, none.
The other thing with respect to that particular project, it has what I expect to be a historic. The sports arena is considered to be historic.
And
so
historic buildings are specifically exempted from this.
Yeah,
legislation.
yeah. So if your project site has biological resources that would be impacted, then you're not going to be able to use this.
So it's important to raise the fact that if it's historic or biological issues, there's got to be a level of scrutiny that this bill doesn't address, essentially.
Exactly.
Right. It does address, it specifically says you can't use them.
Yeah, you wouldn't be able to, but I think Marcela raised a really good issue that I hadn't even thought about. Again, Gary, this is totally evolving. So we're thinking through it as we read it and think about projects that we have. But even like the 15332 exemption, which I mentioned the case that the city won, there is that criteria also has you look at noise, air quality, traffic, public facilities and services. So there is still a level of evaluation that's involved. And when a project is challenged in court, the judge is still looking at the type of analysis that you did. The thing that I really like about this exemption is either it said, okay, you can't use this exemption because you got a historic building on your project site or you got biological resources, or it looked at those other issues and said, here is our checkbox way of dealing with it. And so, yeah, good luck. Someone could come after you for using a statutory, remember it's a statutory exemption. It's written into the statute.
That's a difficult challenge in court.
It's much more difficult. And I do think that I would, and again, I'm just putting this out there. I have no idea because I'm not an attorney either, and I don't even play one on TV. But I know the calculus that developers do when they feel like, yeah, you fit with this as an exemption, but will we get a court challenge? Will we get litigation? Probably. I think they may be more inclined to go with this exemption than engaging in the preparation of an EIR because it is so nice and tight.
Yeah.
Those nice and tight exemptions are so few and far between for the types of projects that we're dealing with, housing projects. So I do think it's going to be helpful, but that it does remain to be seen. But boy, the potential is there, to avoid having to do an EIR.
And Gary, I know we're getting really nerdy on some of these things, so hopefully the people watching this video will reach out if they have questions. But I want to also throw in SB 131 so we don't forget about what that did, because what that did was it also added certain categories of projects into those exemptions. So it's predominantly, I'll call them maybe public works, infrastructure type projects, but nonetheless, those are significant and important because if you think about it, there are times where a jurisdiction themselves is being held up from trying to put in a water pipeline, a road, or whatever it is that has an effect on a private project because that private project is depending on that piece of infrastructure going in. So the fact that jurisdictions now have the ability to expedite some of the infrastructure projects will also have a domino effect.
Yeah, because a lot of the pushback that you get even on infill projects, what's the impact to the city of that project on services and infrastructure? And to the extent that they're small projects, the answer is going to be probably not much, but the extent they're bigger projects, it still is an issue.
Right. The other thing that SB 131 does is if for some, it sets up the reason. So it sets up streamlined environmental review where a project does not qualify for an exemption. And so I, again, as a practitioner, worked in CEQA for over 20 years. As a practitioner, I dealt with so many projects that just by one condition failed to meet the exemption. And again, because it was a bright line, we had no choice.
Right.
And so then you were into that horrible situation of, do I do an MND or do I do a neg deck? So that they actually did address that in the SB 131. If your project fails to meet an exemption by one condition, then the document that you prepare only focuses, the analysis only focuses on that one item.
And that's
It doesn't,
huge.
that's big. You don't
That's
have
huge.
to do an analysis which can be picked apart by people who will be looking, even though it has nothing to do, your project's not impacting anything else. So that is a very big deal. If for some reason that resulted in you having to do an EIR, the legislation says you don't have to look at alternatives. Again, as a practitioner, hallelujah. That is the biggest pain in the you know what when you're preparing a document. Alternatives, and those get picked apart, and you don't have to look at induced growth.
Right.
So if you haven't hit the jackpot and you haven't qualified for an exemption, the legislation does as much as it can to streamline that environmental review that you're required to do. The other item that I want to mention that is in, I believe it's in the AB 130 for City of San Diego is fortunate, has a great program that deals with traffic impacts, VMT. So it's all wrapped up in a neat bow by the EIR that they did for that. But other jurisdictions have a tougher time dealing with VMT and how you mitigate for impacts for VMT. They've set up a statewide, basically VMT bank. So you can buy a credit in that bank or do something in that bank that would be considered to be mitigation, to the extent feasible. That's going to help out a lot of projects. The other thing that I think is important in the future, the legislature adopted a statement that says CEQA should not be used. CEQA should not be weaponized. It should not be used to obstruct projects. The specific wording is in the legislation. I would expect that that's going to be cited in future CEQA lawsuits and will carry a lot of weight, because a lot of the times the judges are looking at what the
Legislative intent, right?
Yes, and the legislature said, okay, you want to know what we intended? This is what we intend.
Well, the
So I think that was
weaponization
sharp.
aspect is huge. I mean, that's really the whole point of this in a sense.
Right.
That's it.
I do want to address one more thing. It's sort of the elephant in the room issue, which is these are bills and exemptions that apply to infill projects only. We're not talking about we're talking about specifically incorporated cities. We're not talking about the unincorporated areas. We're not talking about subdivisions on greenfields. All that is still fair game under sort of the old CEQA rules, correct?
It defines.
I'm sorry, but being incorporated or unincorporated is irrelevant. It's just, you could be an unincorporated city and have an infill project. So, but go ahead, Anna.
Because the legislation specifically defines urban, and it has a fairly loose definition of urban. It sends you to the census, but also if you're surrounded by basically any kind of development. So I think actually it expands that. The legislature had already expanded the infill and have actually created basically an infill exemption for projects in more rural communities. So there's still that opportunity to use that. But this one, yes, it clearly is not meant for greenfield development. So, but we don't have a lot of that. The county has some of that, but we don't have a lot of it within the 18 jurisdictions that make up a big chunk of
right. And that's why I'm dividing my video conversations into two parts, because the question will become how much any of this really matters with respect to delivering more housing or housing solutions to the various cities in the state versus creating opportunities and incentives to build big projects. I mean, big projects are really what we're missing in the state. It'll be interesting to see to what extent infill housing can step up and create enough units to really impact the housing market. So that's what I've left out of this conversation. But I mean, let's face it, this is, as you started the conversation, Marcel and Anna, this is about as huge as it gets in the CEQA world and in the entitlement world. And this is something we've been, arguing about and trying to encourage for all of our careers. And so
Right.
it's a pretty big deal.
And I would say that, so I totally understand where you're coming from, but truly though, the state has been on record now for a long time saying, we do want to focus growth in certain places. We do not want to encourage or create sprawl that has caused us a lot of issues that we're dealing with. So
predominantly.
Yeah, exactly. So it's the legislative intent is quite, they're very upfront about the fact that yes, we want to incentivize development in the right places, and we know that we haven't. And so this is a huge step, I think, in doing that, where the state putting their money where their mouth is.
Yeah. No, and I get that. I don't necessarily agree that's an appropriate policy direction, but it is what it is. That's what the state is declaring.
Yeah, and like I said, I have to give credit to the governor, which that he actually held their feet to the fire and said this is going to pass, or we're not going to get through the budget. And
right, we won't have a budget.
the fact that this was
legislatively brilliant,
part of the budget trailer bills,
yeah,
which is why I think everybody was like, "Whoa, where did that come from?"
Yeah.
So
I had no clue.
I was actually on a phone call with the client who was talking to me about the bill. He's like, "Hey, did you see this?" I'm like, "Oh," I'm thinking it was one of the normal ones. And I was like, "Oh, it probably won't do anything. It's probably no big deal." And then all of a sudden I read it. I was like, "Oh my gosh."
It wasn't just another bite around the edges. And I did what Anna did. I mean, I listened to the whole press conference and I tried to get my head around this immediately when I heard about it. But this has been a very clarifying conversation. And I appreciate your time. Again, I always think about you when it comes to matters relating to the complexity of real estate development entitlement.
Well, we appreciate the opportunity to have this conversation. I think we will probably have some follow-up conversations on this 3 months and 6 months from now when we see how it's actually being implemented, not just in San Diego County, but throughout
But in other jurisdictions. We're going to be watching the other jurisdictions. I do think it would be worth, in your subsequent conversation, looking at the permit streamlining aspect of it, because I do think that is pretty significant. Yeah. It is.
You got it. Thank you again, ladies.
Thank you, Gary. Appreciate your time.
Have a good rest of your week. We'll get this out shortly.
Okay, take care.
Thanks, Gary.
Bye-bye.
Bye.